Hi everyone, today's video is about blanket assessments, what they are and why they don't work. I'm not going to go into detail about the background of the off-payroll rules here because we have lots of other content that you can read and watch to understand the legislation in more detail. What I'm going to talk to you about in this video is how businesses can best manage their legal obligation to conduct IR35 assessments on their PSC contractors from the 6th of April 2021 onwards. The new legislation requires clients, that is, the companies who ultimately benefit from the PSC's services, if they are a public authority or a medium or large private sector company, to make a determination as to whether a role or assignment is genuinely self-employed for tax purposes, that is outside IR35, or employed for tax purposes, that is inside IR35. If you don't conduct IR35 assessments using reasonable care, then you as the client are liable for the tax and national insurance contributions that are or would be payable under that assignment. What that means in practice is that clients will be required to pay to HMRC all of the income tax, the employees and the employer's national insurance contributions, and any apprenticeship levy payments that might be due on the assignment for the duration of the assignment. You'll also be required to account for any interest on those payments, if the liability arises from a previous tax year, for example, and possibly for additional penalties for non-compliance that HMRC may choose to impose. Now that sounds scary, and it is. You know, those liabilities can exceed tens of thousands of pounds per contractor per tax year, depending on the pay rate to the PSC. So it is really important that hirers take their obligations seriously and take appropriate steps to manage the legislation properly. We talk in more detail about reasonable care in other content on this portal, so I'm not going to go into detail here about what constitutes reasonable care. But I do want to clarify that HMRC have clearly specified that blanket determinations won't discharge a client's duty of reasonable care. Now, blanket determinations are where a client decides that all of its PSC contractors are inside IR35 or they're all outside IR35 without undertaking a proper assessment of the facts and circumstances of each assignment. Most clients who are considering blanket assessments intend to assess all PSCs as being inside IR35 in order to take the risk-averse approach going forward. And it's tempting to consider that risk-averse approach because it means you don't have to go to the trouble of doing IR35 assessments, and they're hard to do, and because employee levels of tax and national insurance will be paid for all of the assignments. So surely HMRC is less likely to investigate your business in the future. But unfortunately, that's just not the case. The off-payroll rules that are coming into effect on the 6th of April 2021 for the private sector have already been in place since 2017 for the public sector. And many public authorities decided to issue these blanket determinations as they had very little time to prepare for the new rules. Their decision to take these blanket determinations had severe commercial consequences, and we'll talk about that next. But also, from a legislative perspective, HMRC has closed that loophole in the 2021 changes. So what that means is, when the off-payroll rules come into force on the 6th of April, they will clearly state that if a client makes a blanket determination for its PSC contractors and doesn't undertake individual assessments, then the client will not have discharged its duty of reasonable care, and it will be liable for all of the taxes and national insurance contributions I've already mentioned. However, here's the real stick in this scenario. Clients who use blanket assessments will be liable for all of those payments, even if those payments have already been paid to HMRC by another party in the chain. So, for example, Even if the PSC worker has paid all of the income tax payable under the assignment, the client will be charged the same amount again. The fact that other people might have paid those costs already is considered irrelevant. So when you consider the potential for tens of thousands of pounds in liabilities per contractor per tax year, if you don't assess PSC contractors properly, well, blanket determinations become much less attractive. It isn't just the legislative penalties, though. There are some real commercial disadvantages of offering or deciding to take a blanket approach. Firstly, PSC contractors will certainly challenge the determination, and of course under the new rules you are required to implement a status disagreement process to consider any challenges. And contractors using that status challenge process creates more work for you and creates bad feeling between you and your contractors. Secondly, many PSCs are staging mass walkouts from client sites in protest of blanket assessments, causing immeasurable disruption to projects. And thirdly, a blanket approach will have serious reputational repercussions. And clients should be aware that, contractors, they are a very close-knit community. They share a lot of information about good clients and bad clients. And if you've gained a poor reputation for trying to circumvent the off-payroll rules by using blanket determinations, well, you simply won't attract the best talent and the best skill in the future. It's also important to bear in mind that the difference for contractors of being inside and outside IR35 is about 20 to 25% difference in what we call take-home pay. And in some cases, it's far more than that, actually. It's far higher. So for some contractors, they simply can't pay their bills if they are deemed to be inside IR35. They'll have to leave their current assignment and move to another company where the rate is higher or the role is outside IR35. And this brings me on to my final reason for avoiding blanket determinations. And I'm going to use an example to better illustrate the problem. You're an engineering company and you have a role to fill in May 2021, so after the new rules are implemented. And the role is for a design engineer. You've decided as a company that all PSC assignments are automatically deemed inside IR35. That, by its very nature, includes all of your design engineer roles. Your biggest competitor, who's based a few miles away from you, has undertaken proper assessments for each of their roles and determined that the role of design engineer in their business is outside IR35. And they're hiring at the same time as you. How many contractors do you think will apply for your design engineer role, and how many will apply for your competitors? Do you think your role will attract the most highly skilled contractors, or only those who are really desperate for any role? Whoever you do engage will certainly leave as soon as another similar role opens up that is outside IR35, which gives you no certainty of the completion of services and no continuity of skill set. With such economic uncertainty at the moment, most businesses are going to need temporary workers and contractors in greater numbers over the coming months, and they need that flexibility of resource. And if you want to use the most productive and skilled contractors to get that work done most efficiently, assessing PSC contractors fairly and ensuring that the IR35 assessments are done with sufficient expertise to get the correct result will minimise both your legislative and your commercial risks once the new rules go live. HMRC guidance is clear that clients can engage with external expert assessors to help them with IR35 status determinations, providing the assessments are fair, accurate, and can evidence reasonable care. So using a professional advisor to help you manage the rules instead of using blanket determinations is definitely your best option. That's it from me. I hope you enjoyed today's video, and I'll be back again soon.